We already have some people joining. Hi, everybody. If you'd like to just, if you have access to the chat function, if you'd like to just say where you're joining us from in the chat, that would be great. Just introduce yourselves. We have somebody from Minneapolis. Great. Hi, Rachel. Washington. Hey, Jessica. San Diego. Warmer than the rest of us, I'm assuming. Hi, Chris. Hi, Ellen from Missouri. Wow, we are covering the United States today. It's very cool. I'm in New York. Santa Fe, New Mexico. Hi, Maria. Rachel has mentioned that if attendees want to change their chat setting to all panelist attendees, then everybody can see. So do that if you are so inclined. Norma is joining us from Austin. Hi, Norma. And that may be everybody who's on so far. Welcome, everybody. As people join, they should feel inclined to tell us where they're joining from. At any point during this webinar, you can go ahead and type in some questions. I will introduce myself. My name is Jennifer. I am the founder and administrator of Caregiver Collective. We'll get to that in a minute, but this is the Elder Law Bootcamp for Millennial Caregivers. Yeah, there we are. I'm Jennifer. I am 38 and I founded Caregiver Collective about 4 years ago. When I was in my early 30s, I was caregiver to my dad who had progressive supranuclear palsy. And I quickly realized at the time that there were no resources available for people my age going through it, and that there are over 10 million of us in the United States. So while we are dealing with our own lives and establishing our careers, we are also learning the ins and outs of caregiving for a family member. One of the questions that comes up in Caregiver Collective, which is an online support group and informational resource for millennial caregivers, is the concept of caregiving law. Elder law is something that in our 20s and 30s we know little to nothing about, and it is crucial to the caregiving process, no matter what the relationship is or the condition of the loved one that you're caring for. It's critical to be familiar with the terms of elder law and caregiving laws and the documents that are necessary to have in place. So luckily, Cathy was willing to join us today to give us the basics of caregiving law. So Cathy, I will let you introduce yourself.
Hi, everyone. Oh my gosh, I'm so excited. We have people from all over the country. That's fantastic. I have been a caregiver for 8 different family members and friends over the last 30 years. So I too started this when we weren't called millennials, but I was in my 30s at the time, and it was also brand new to me. And fortunately, I would say for me, what I was able to do, I was a small town practice lawyer at the time, and I actually honed my practice down to only be an elder law attorney because I saw the writing on the wall for myself personally. But as you all know, this has grown into an unimaginable wave of things that we're all dealing with at all ages. So I've written a couple of books, and I educate people on their legal and financial. I don't know if you heard or not, but I am obviously an elder lawyer. That was our last slide, but I've also been a caregiver for 8 different family members and friends over the last 30 years. So I come at this from both sides. And I believe that all of us, feel like when we get into this caregiving thing that we think we lose our brain, our heart, and our courage, right? We're getting on this yellow brick road to nowhere, and we don't know what is happening to us. So this is a boot camp where we're going to learn about exactly the things that we need to know sort of from the beginning. And some of you may be very familiar with this, and I certainly appreciate that you've already taken the time to know it. Some of you may not know any of it, so I'll go through it sort of at a medium pace. And again, as Jennifer said, you can type questions in the chat box as we go. I'm totally fine with that. And we'll answer them either as we go or at the end. But while you think of the questions, I really encourage you to put them in there while you're thinking of it. I think that would be most helpful for all of us. So if I only had a brain, the two things that everybody thinks that you should know when you become a caregiver are powers of attorney and guardianship. What are they? Okay, let's do the 30-second definition of power of attorney. There's generally two kinds. There's a healthcare power of attorney or proxy. Sometimes they call it that, but it's the same thing. And there's a financial power of attorney, and that's very often called a durable financial power of attorney. Almost everyone does a durable one now, but durable, the critical piece of that means that if you become disabled, it endures, that you really mean for it to be in place once you've put it there, even if you can't fix it or change it because now you are disabled, okay? But what is it? This is what it is. A power of attorney is a document that you sign or your loved one signs that says, I give power to my agent. That's the person you're giving power to. They're now called your agent, to act as if they are me in any capacity, financially, in the financial power of attorney. So they can open a bank account, close a bank account, use my credit card, buy a car, buy a house, sell a car that's mine. They can do anything that you could do if they were as if they're stepping in your shoes. So it is a very powerful document. You are handing over lots and lots of power. A healthcare power of attorney is almost identically the same, except under a healthcare situation. So you're giving the person, your agent, the power to call the hospital, talk to your doctor, call Medicare, call Social Security, anything that has to do with your medical issues. They have the power to take care of that. So once you create that document and give them that power, you now have someone who can do things for you if you are incapacitated. In the alternative, there's a guardianship, which is, and you know that part in The Wizard of Oz where he says the hypotenuse is the sum of the parts A, B, and C. I don't even remember what he says. He just does this really quick math thing. Well, that's what this is. Now, this is clearly a definition from the Pennsylvania statutes. I'm an attorney in Pennsylvania, and I just want you to know that generally this is true everywhere. So I'm moving that over because I don't know if it's on your screen, but it says when an adult's ability to receive and evaluate information, and you can read a slide. I don't need to read to you, but the point of it is this. If you take 2 seconds to read it, it says someone is unable to manage their financial resources or their health requirements, and the court is going to step in and help take care of that. The court, because somebody didn't sign a power of attorney. So what happens next? What are the important differences between that power of attorney and that guardianship? So a power of attorney, again, we're going to do that durable healthcare and financial power of attorney. This picture is me with my friend. My friend Lisa fell down the stairs 10 years ago and suffered a traumatic brain injury. I became her power of attorney, both healthcare and financial, as did another friend, because she had no one in her life to help her out. She was able to sign those documents because even though she had a traumatic brain injury, it did not affect her cognitive function, and the doctor agreed that she could sign and understand legal documents. We were very fortunate that at that point in time, she could understand, and the doctor agreed that she was capable of understanding that she was giving someone legal authority to help her out. That opened the door for us for 10 years to take care of her affairs, both medically and financially. Now, what's interesting about this, and you may run across this yourselves, is I was her financial power of attorney. Our friend Terry was her healthcare power of attorney. We didn't share the job. Quite frankly, we didn't want to. We had enough to do with one job each, right? So it's not only possible to split that job, but if you can, and it makes it easier for you, I highly recommend it. My mother is 91 years old, super healthy, doing great, but she's had issues over the years. Again, I'm her financial power of attorney. My sister Maggie, who is a nurse, is her healthcare power of attorney. Why is that great? Well, two reasons it's great. I'm not always on call. I have someone else to share the burden with. And my mom has someone who's a nurse, you know, who really understands the whole process about what to do in a healthcare situation. And it just helps alleviate the burden. The other thing I want to say about this, which was great for Terry and I, is we were each other's alternate. So that if something happened to Terry or if something happened to Cathy, Lisa still had somebody to help her as a power of attorney. If you already have these documents, I cannot encourage you enough to go home, look at them, or you're probably in your home, and make sure that there's an alternate in there for someone to take the job if you're in charge of it now, in case something happens to you. Because as you know, there's no guarantees. Something can happen to any of us. Because if you don't have that alternate, then what happens next, yes, is the court gets involved. You have a guardianship. And why don't we like those? I mean, they're great if you have it and because you have no other alternative and you absolutely need someone to be in charge of your loved one's affairs, but the cost and the logistics is a nightmare. So let me tell you how it works. Say my husband has a stroke tomorrow and I have no power of attorney documents and he clearly is incapacitated. There is no way he can sign anything. Nobody will allow him, and maybe he couldn't even if he wanted to. What I have to do is go to an attorney, ask them to file papers with the court, ask the court to appoint me as his guardian, even though I'm his spouse. You have to understand, especially in today's modern world, that they've taken a lot of authority away from spouses without legal documentation behind it. And we're going to talk more about that later because it's critical for you to understand where that can hurt people, especially in a spousal situation. But let's just go back to the logistics. I go to a lawyer, they go to court, they have to get a doctor to testify either in writing or in person. That costs money and time. This is expensive. And then the court requires me to report to them on an annual basis every penny I spend on my spouse and every doctor visit I have with him for his care. Can you imagine the burden of that reporting when you're already burdened with taking care of someone? I mean, whether it's a good burden because you love them, but nonetheless, it's more time and effort. And it is just something, if you can avoid, you absolutely should. And so that's why these powers of attorney now, while people are capable of signing them, regardless of their health status, if they're mentally capable and mentally competent, you should do so. And let's just talk about that last thing where it says no alternate, so choose wisely. When you go to court and get a guardian, they don't give you an alternate. So if I'm appointed the guardian for my spouse and I die before him, somebody has to go back and start the process all over again. And that reporting requirement in Pennsylvania, we just started that, is a computerized way to do it, which for many is great, but for some, not so much. So for you guys, you know, you're in the millennial group, so this is easy for you, but you may have a parent who's also doing this. You might not be the only one in your family. You may have a loved one who's older is doing this. They might not be computer savvy, or they might not have access to a computer. So it comes with its own set of burdens. So guardianship is the court of last resort, literally. And the way to avoid that is to plan for a crisis beforehand if possible. And even you may already be in a situation, but you may still be able, like my girlfriend who fell down the stairs, you may still be able to get a power of attorney depending on their status. So I'm always going to tell you that the first and most important tools in your toolbox are going to be your powers of attorney. So get them, and also always, always, always try to find an alternate, because that is going to make your life easier somewhere along the line. Okay, So now I have my POA, and lawyers, like everyone else, we love, these anagrams, like how we make things shorter. POA means power of attorney. So I have my POA. Now what? Where can that help me or maybe get me in trouble? And I don't mean in trouble in the sense that you're going to get in trouble. I mean in the sense that maybe your power of attorney doesn't have all the language that you need. Now, I am beautifully talking to people all over the country. And the thing about elder law is, and any law, is that it's state specific. So I'm going to tell you how it occurs and works in Pennsylvania. The interesting part about that is Pennsylvania is super restrictive. So what I tell you might not be true in your state. It might be easier in your state. You might have more leeway to get things done in your state, but I can assure you that if it complies with Pennsylvania law, you're probably going to be okay. So let me tell you where we have stumbling blocks and where you might want to know about that and discuss that if you don't have a power of attorney or if you have an old power of attorney. We changed our laws in 2015, and this seemed to be somewhere around the late 20s, 2012, 2013, 14, 15, a lot of the states started to change their laws about how powers of attorney had to be more specific in the powers that they were granting. And the reason for that was, quite frankly, they were seeing a lot of elder abuse. They were seeing people taking advantage of elders or people who need power of attorney, both financially and physically. And so they wanted to make sure that every one of those documents had very strict language requirements to comply with the wishes of the person giving the power. So where does that happen? Obviously, always with money, right? Money's the issue. Transferring assets. You need to understand, and this is a crazy thing that had an unintended consequence. When we started saving all of our money in 401ks and IRAs and 403bs, those became savings accounts that could only be owned by one person. None of those are ever joint, ever. My mom and her generation before that, everything was joint. Joint savings account, joint banking account, joint CDs, everything was joint. So, the husband and wife owned it together, or sometimes children owned it with their parents together. That's fantastic. But what happens when you have these 401ks, IRAs, 403bs that are not joint and somebody gets sick? And the spouse, let's talk about spouses for a minute. The spouse needs that money to maintain her living expenses. Let's say your husband is sick, he's in a nursing home, or he's, suffering and he needs to go to rehab for a period of time. Let's say you need that 401k or that IRA or that 403b. You've been using that for your living expenses. You do not have permission or access to that if your power of attorney doesn't allow gifting. Giving money between spouses is literally considered gifting if it's not joint. And so the language in your power of attorney set has to say, I give my spouse unlimited gifting power, which means he or she can take whatever money they want that's mine and use it for whatever they need. That's really critical language, because without that, you could be limited to not taking any money at all out of that 401k, or you could have what we call limited gifting, which usually means $15,000 a year, which sounds like a weird number, but that number is based on the federal allowable amount of gifting without a gift tax. I'm sure you've heard of that, and that's what that number means. That's all that it means. But in my case, let's say my husband has a stroke and we're living off of his nice big fat 401k because I've stepped out of the workforce 8 times to be a caregiver. I don't have the retirement funds that he has, and that's our household money. If he went into a nursing home and I was incapable of touching that money because I didn't have a power of attorney that said unlimited gifting, I would be basically losing the money to pay our mortgage, to pay our living expenses, etc. If I needed to go get a guardianship because I didn't get that power of attorney, it's kind of unlikely that the court would even let me have any of that money because the nursing home would expect to keep that for his care. That's not my money. It is a scary thought. And all I'm meant to do here is to prepare you to read those documents and make sure they do what you need them to do. And that doesn't even need to be between spouses. We have, sometimes I have clients who are a mother and an only child. Sure, get some unlimited gifting there. You're taking care of their expenses. Maybe you're living together. It just depends on the situation. But that is definitely a conversation that you should be having with an elder attorney, either to update your documents or to create these documents. Okay, so transferring assets. And also, I'm sure you've all heard of that 5-year look back period. Everybody talks about the 5-year look back period. What does that actually mean? And why is it critical here? 5-year look back period means if someone you love goes into a nursing home and you're going to ask the government to help pay for that bill, that $12,000 a month bill or $8,000 a month bill because you're running out of money, what did they do with all of their money for the last 5 years? Anything that they transferred to anyone without the need to do so is considered a gift. For example, if they gave someone a $10,000 wedding gift, that's literally a gift. If they gave someone a car because they weren't driving it anymore, still a gift. And the value of that could be assessed against that person to say, basically, you got to bring that back. That has to be used for their nursing home. But if the authority allows gifting and it doesn't really affect how much money the person has, you might be able to justify that. My only point in that conversation is because, quite frankly, that 5-year look back period is almost a whole other Medicaid seminar that we could do. My point in telling you that is the words gifting have to be in a power of attorney under any circumstances if you hope to do your job appropriately. Okay, let's talk about beneficiary designations. I cannot tell you how many people have come to me and said, my wife was a school teacher. She got very sick. She had life insurance at work. And while we were going through all of her stuff, while she's, we're taking care of her, we found out she forgot to put a beneficiary designation on her life insurance. And she'd like to make it the children. And we're taking care of her, so that would be nice because it might pay us back for the expenses that we're putting out. Unless the power of attorney allows you to change beneficiary designations. And that change means from nobody to somebody. It doesn't just mean from one person to another. You probably cannot do that if they are incapacitated. So check that POA, make sure it gives you authority, if appropriate, to change beneficiary designations. Many people have second spouses. They put their first spouse on that life insurance policy and never changed it. They forgot to do it. Check it out. Make sure that you can do that. And again, that goes to Medicaid planning. The third thing, Medicaid planning, with gifting and beneficiary designations, et cetera, again, could be a whole seminar that we could do another day. But I just want you to know that you can't do any classic Medicaid planning, which is moving funds around to protect them for a healthy spouse, to protect them for a disabled child, to protect them for a legacy that somebody might want to leave without having a good, clear-cut power of attorney. Okay, so that's the financial one, and that's just a few tips about the kind of language that needs to be in there. Healthcare decisions. So this is the healthcare power of attorney or the healthcare proxy. These are actually give much more leeway than the financial one. I find that in general, the healthcare world, and you guys might agree with that, I think you might find that they're more willing to talk to you before they start accosting you about, oh, do you have a power of attorney? The biggest question they always ask is the living will. That every hospital, you walk in the door, they say, do you have a living will? Which is amusing to me because it's probably the one you need the least. But nonetheless, you have to have that healthcare power of attorney at some point in time, and the sooner the better, of course. But what a lot of people forget is it's not just a hospital situation that helps you with. It helps you talk to Medicare. It helps you talk to the Veterans Administration if you're dealing with a veteran. It helps you talk to the pharmacy, right? Durable medical equipment. So many things outside of just a hospital and a doctor. That's why it's a critical piece. And again, I'm going to ask you to make sure that you have an alternate, because sometimes maybe you just want to take a vacation and you actually possibly can. If so, wouldn't it be great if somebody else was right there in line already on those documents to take over taking care of all of these business things? So you can see right there, I say, please don't share this job. I'm not a fan of having two people have equal power. It's kind of like the Supreme Court. We always have an odd number because we need a decider. We need someone to make a decision. In some rare cases, there's a family that's got, two siblings who always agree, they're always on the same page, and they want to be powers of attorney. I guess that's great, but unfortunately, sometimes a financial institution or healthcare institution would say, well, we got to talk to both of you. A problem, maybe. So for me, I'd always pick one and an alternate, even two alternates if you want, but this is just a personal feeling that sharing sometimes just makes it harder for you. Okay.
Cathy, we have a question, and that
Sure.
is, how often should power of attorneys be updated?
I say 5 years. Check it out every 5 years. Make sure that the person that you want is there. Make sure that they're capable of still doing the job. And you can even make a quick call, and God forbid your lawyer that filled it out for you, they should not charge you for that. Just say, I'm just checking. Has anything changed? And my power of attorney seems okay. Has anything changed in the law, or am I good? But I think 5 years is a good rule of thumb. That's a great question. Thank you. And then I'm going to ask each and every one of you, do you have a power of attorney for yourself? This is wonderful that you have one for your ill loved one that you're caring for. But do you know how often caregivers actually get sicker than the one they're caring for, even if it's temporary? I mean, statistically, it's been proven. And you all know why. This is hard. We're exhausted. You have to have a power of attorney for yourself. Please.
So far, we have one caregiver who's on the ball and has said that she does have a power of attorney for herself.
Well, you give her a big hug.
Well done, Rachel.
That's right. And I'm just going to throw this out there just as a thought process. When my kids went to college at 18, I made them sign a power of attorney. It was not nearly as complex as the one that I make for my clients. But the point was, I didn't want them going to college, being far away, and somebody telling me they wouldn't talk to me either for their financial problem or their healthcare problem. So they're adults. And that's my only point, is we're all adults here, and people are going to expect you to have that. So then the last question is, what if I didn't get a power of attorney? Is it too late? The answer is maybe yes, maybe no. It really depends on mental capacity. And you know what's funny about that, you guys? Mental capacity doesn't really have a clear-cut definition anywhere. If you can prove to a lawyer that the person you're taking in there understands what they're signing, they know what they're doing, they should be able to sign a document. So it might not be too late. If it's not, do it now. If it is too late, then I'm sorry to say that guardianship is your next set of, work. So a poem to remember. POA, remember that means power of attorney. Powers of attorney are for live people who are ill. Wills are for people who have passed away. I want you to know the distinction, because a lot of people will say to me, I'm my mom's executor, I'm my husband's executor. That means you can take care of things after they have died. So if you're an executor, you can't take care of anything if somebody is sick. You have to have that POA. So POA alive today. Once you pass away, only an executor can play. Powers of attorney die with people. They are no good. So you need both those documents. But for live people, you need a power of attorney. For people who have passed away, you need a will, because neither of those documents can work together. Okay? So now we have a brain, Don't we feel really smart now? Now we need a heart, unfortunately. There are difficult decisions, and for those, we have other special documents. We've got living wills, DNRs, and POLSTs, because it's great to have a heart. Honestly, you wouldn't be a caregiver if you didn't, but you also have to have the tools. So let's talk about these documents when you have to use your heart. First is an advance directive or living will. Oh, the POLST came up too. I just want to say for the advance directive and living will, they're the same thing. If you hear the word advance directive, if you heard the living will, it's just like P. Diddy and Sean Combs are the same person. They're identical. What they do is identical. This is the document that if you are in a permanent vegetative state, and that's really important, a permanent vegetative state, you have decided what you want done. And often these documents come with boxes. It'll say, I want chemotherapy, or I only want palliative care. I do not want a feeding tube. I do not want a respiratory tube, something like that. And you click the boxes, what I do want, what I don't want. In the vernacular, this is a pull the plug or don't pull the plug document. That's really what it means. So, two things. Yes, I want you to have that. Yes, I want your loved one to have it, but not for the reasons most people think. In Pennsylvania, these documents are not legally binding. So if the hospital doesn't listen to you, they don't do what it says, or you didn't get it to them and they didn't know what to do, you can't sue them. But what's wonderful about these documents is if mom signs that document and I have 8 siblings and I'm in charge, and they all come to the hospital because all of a sudden I've been doing this all by myself, but everybody's got an opinion about what I'm supposed to do, I'm not the decider. The document decides. Mom said what she wanted, and that's what we're doing. It takes the caregiver off the hook. It gives you authority, it gives you heart, but it doesn't give you as much pain because you are really not deciding. Your loved one already made the decision for you. That's why I love that document. So I highly recommend it. I think it's a great thing to have. And if you can get one of those fairly easily, honestly, you could probably even get them online. Every state is different though. I almost rarely recommend people getting things online because there's so many legal manipulations and complications. But that document is just a good thing to have because it sparks a conversation that's really important. Now, this is called in Pennsylvania a POLST. I know and the P stands for Pennsylvania. So it's called, I think it's called a MOLST in some states because it means medical orders for life-sustaining treatment. I don't know if you've seen these. They're usually hot pink. And the reason they're hot pink is they're supposed to travel with the sick person. So you keep it on your refrigerator. Some people keep it in their freezer. And if an EMT comes, it's supposed to go with them. This is signed by a doctor, a physician. I like these when someone is chronically ill and seriously ill. I'm not completely crazy about them when someone is just needs caregiving because it requires a doctor's signature. It comes up, it requires some kinds of decision making with an EMT that I'm not sure they're prepared to make. And I think you need to become familiar with it. I just want to tell you this because I had this conversation last week with my nephew, who is an emergency room doctor, who loves this. He loves it because he feels like it gives the doctor direction. And I understand that, but he doesn't know the patient. And I think that's more important for you as a caregiver to be making some decisions. So I'm almost thinking this is a document of last resort. That's my personal feeling. If you come across this document, because I know they're giving it out in nursing homes and assisted living places, I just want to say proceed with caution, okay? Make sure that this is what you want and that, you know, once a doctor signs it, you really truly are okay with it. And you can absolutely, you know, shut it down anytime you want. You can get rid of it and not have it if you've changed your mind. Okay. And finally, in this section, DNRs. I just want you to know that DNRs are not either of the first two things. It's like that old Sesame Street. One of these things is not like the other. DNRs, you know, means do not resuscitate. And that is really for when you have decided that that is exactly what you want in the situation that you have. It is almost 90% of the time attached to someone who is permanently in a nursing home or who is in a hospital setting, that you've decided in that hospital setting, we want a DNR. The other two things, the advance directive and the POST, don't usually act as a DNR at all. So you need to know that. And if you don't want a DNR, don't worry. You don't have a DNR unless you actively put it in place.
Malin commented about the advance directive and said that her family member had one in place and it saved her when she didn't have power of attorney. And so she said, we learned the hard way, and she has one herself. So good for you, Malin.
And also let me say,
my age, so good for you.
Well, and let me say thank you for, I always like to hear that the things I think are true are in fact actually true, that it did save her, because that's what I think about that document, that it is really a life-saving document for a family member, just in so many situations, right? Especially, like I said, when people come out of the woodwork and have an opinion. So thanks for sharing that. I truly appreciate that. Okay, so now we have a brain and a heart. What's left? Courage. You are an advocate. You know that now, right? You have entered the world where you are the person who's in charge. You are the king of the forest, whether you like it or not. So what does that mean? Well, that means not only are you in charge, but you're going to be making important decisions. And you know this, you've already done it a million times, but I want to talk to you about something that has come into play in the last, I think it's almost 2 years, but not quite, called the MOON form. I don't know if you know about this. MOON stands for Medicare Outpatient Observation Notice. And this is really a crazy critical thing. Now, this only applies to people who have Medicare. So you may or may not be in this realm. But the observation status also applies to all of us, and we might just want to know about it, whether we have someone on Medicare or not. So the real moon is this one on the left-hand side. We just like it. It does good things. The bad moon is the one on the right-hand side. And this is me giving a presentation, and you'd see me in a hospital gown. And what I've done is put the hospital gown on, like we always do, backwards. And, we call this mooning people, which is not a good thing. It's the same with the Medicare Outpatient Observation Notice. It's not a good thing. And this is why. When you go into an emergency room, and many people enter the hospital now through an emergency room. I don't know about you, but every time I call the doctor, if I'm taking care of a loved one, they just say, go to the emergency room if they think it's not appropriate for you to see them. So you take them to the emergency room and they start doing whatever, tests, whatever. You are the person who knows your loved one best, right? And you are concerned that your loved one is seriously ill. And so they start doing their tests and their blood work at whatever, and they bring you in this form, this MOON form, and you may never have seen it, and they may slide it in with 10 other forms, and you don't even know what you're signing. But what you are signing is a form that says, my loved one is under observation. He is or she is not admitted to the hospital. And that can go on for 72 hours, 5 days, whatever. If they don't admit them to the hospital, Part B Medicare does not pay for anything. Now, Part A is hospitalization. However, Part A only pays certain things as well under observation. And you can end up with thousands of dollars in medical bills because your loved one is under observation. Now, when is it okay to sign the MOON form? So your mother breaks her wrist, they put a cast on it, you're there 8 or 10 hours, they take x-rays, everything's fine, they tell you to go see the orthopedic surgeon 3 days from now, you sign a form, you take mom home. Totally fine. I don't have a problem with that. However, if you have something like I did with my brother-in-law who had multiple sclerosis, we were in and out of the hospital on a regular basis. He had a lot of issues, but when he would get a urinary tract infection, which for him was devastating and looked like dementia, and I'm sure, I don't know if you've seen this, but it can look like dementia, and they don't know my brother-in-law. I knew him. He didn't have dementia. He didn't have 1 ounce of dementia. But when he started to react to this urinary tract infection, it usually meant he needed antibiotics in a big way through an IV, and it was going to be a few days in the hospital. but they just assumed he was an old man with dementia. And they took a couple of blood tests and they were going to keep him under observation. And this could go on for 2 or 3 days before they actually found an infection because they, the lab work didn't come back yet. I had to fight for him to be admitted to the hospital. So here's the answer to the question you didn't even ask. What can you do? What can you do if they try to get you to sign the Moon form and you think your loved one needs to be admitted? Number one, do not sign that form. You don't have to sign it. Don't sign it. So you're not agreeing to that. Number two, ask to speak to the emergency room doctor and tell them, listen, this is not my loved one. This is not how he acts. This is not my experience with him. This is much more serious. He does not have dementia. I don't know why you're, coming to that conclusion, but I am telling you that this is more serious than it appears because this is not how he acts. This is his medical history. This is what I know about him, et cetera, et cetera. You're the one who has the knowledge. You're the advocate. They're not the advocate for you. You're the advocate. Number three, if that doesn't work, if you have a family doctor for your loved one, call your family doctor. Ask them to go to bat for you. Ask them to speak to the emergency room doctor. You'd be shocked at how many times they will actually do that for you. They will. And especially if they've been their family doctor for a long time and they know your patient. The fourth thing is, if none of those things work and they continue to keep your loved one under observation, you can ultimately appeal this. Now, the thing that you have on your side is, number one, you didn't sign the form. But even if you did sign the form, just know that you can still appeal. And when I say appeal, you must know if you have a patient on Medicare, if you're caring for something like that, you get in the mail these envelopes every week, every month. Oh, here's all the things that you've done with Medicare, blah, blah, blah. And if you want to appeal this, here's the form, here's this, you sign it, you send it back. It seems daunting to you, but I assure you, you don't have to be a lawyer to do that. You can fill out a form and say, my loved one was sick. He was ultimately admitted, or they sent him home. We came back. He was ultimately admitted. We should not have to pay these bills because we did not agree with observation. You can do that. And trust me, I'd say absolutely try yourself the first time because you'll probably win. So I just want you to be aware of the Moon form. A lot of people aren't aware of it. So know that they may be trying to do that. And number two, if you don't think it's appropriate, don't sign it. And there's some things you can do to help get your loved one admitted. Okay. So the last thing I want to talk to you about, because you have a heart, is filial responsibility. This is my mom. This is me and my mom. She's 90 years old in this picture. It's not her birthday. It's my birthday. Filial responsibility. I say no good deed goes unpunished because you can see that there are 29 states and Puerto Rico listed there. Those states and Puerto Rico have laws that say you might be responsible to pay for your mother's or your parents' nursing home bills if they can't afford to pay. I hate to tell you this, but Pennsylvania, unfortunately, was the leader in this horrible and remarkable law. It is only case law. Well, it's founded on old laws like from the 1920s when people were really destitute and there weren't many nursing homes and they weren't living past, 45. But right now, if you're in any of those states, you might be a state that has filial responsibility. We are not seeing nursing homes on a regular basis suing people for this. But one of the things you can do to protect yourself is have that power of attorney. And when you're signing documents for your parents, either to go into rehab or a nursing home or assisted living, whether temporary or permanent, you always, always, always sign as power of attorney. You never sign as responsible party. Never do that. You are a power of attorney. You are not the responsible party for your parents. You are only there as a power of attorney to help out. So I just wanted to bring that to your attention. It seems like the laws are starting to be repealed. It seems like as long as you're not hiding money that was your parents and, stashing it for yourself, the Department of Human Services or aging, whatever you have in your state, seems to be not pursuing adult children, but I just wanted you to be aware of it. It's something that's out there and, can be kind of painful if you don't know it's coming. Okay, so these are the 9 things that you can have a planning discussion with an elder lawyer. We talked about most of them in one way or another. We didn't talk about number 4, titling of assets, but that means whether something's joint or not joint, and you might want to do that with certain things. You might not. It's a conversation you should be having with an attorney about bank accounts, property, real estate, things like that. It's important, and you could be saving taxes or inheritance tax, or, you know, you could be doing good things with that. Pretty much, other than trusts, the only other thing we didn't talk about, trusts are very complex. I will tell you that you'll often hear in the news and on TV, oh, get a trust, it avoids probate. 99% of the time, that's not important to avoid probate because it's not expensive, although I think I heard that California is, but most states it is not. Trusts are often for the very wealthy that need to do things, but also they can be appropriate in situations where someone has real estate or a sick child or you know, a disabled child permanently who's an adult. All I'm saying is it's a conversation you should be having with an elder lawyer. And just real quick, I'm going to throw in there the difference between an elder lawyer and a state lawyer. And this is actually a seminar that I do a whole hour on. But generally, it's kind of like those POAs and wills. Elder lawyers are for live people, people who are sick, who have issues with illness, issues with disability, issues with age. Estate lawyers are for dead people. Now, granted, you don't go when you're dead, but it's about when you're planning for what happens when I die. That's what an estate lawyer does. They can be the same person. They can have the same education and be the same person, but often they are very, very different and very separate. Make sure that your attorney does the things that you want them to do and that you're there for that purpose, okay? So I know this is going to be available as a recording, so those 9 things will be there for you to go back to, you know, as many times as you need to. Resources. These are just some reasons. Everyone has an area agency on aging. That's what we call them in many of the states. You may call it something else. It may be Department of Health and Human Services, but there is a plethora of information there for you that is free. Take advantage of that. Medicare.gov is actually a great website. I know you find that hard to believe, but it's actually true. It's easy to read. It's informative. It leads you to other links. It's a great, great website. Alzheimer's.org, also a wonderful website. Whether you're dealing with Alzheimer's or not, they have amazing caregiving resources, as does caregiving.com. Number 5, agingcare.com. The reason I love this one is they do a question and answer forum every day, all day. People are just going in there asking all kinds of crazy questions. What if I can't get my loved one to take a bath? What do I do because I don't have a power of attorney? What can I do about, I'm a joint account owner and my brother is causing me trouble. It's just a wonderful place to go look at all the questions that are actually coming forward, or to even ask your own question and to see the kinds of answers. It's really a helpful tool. I have found it to be wonderful. So resources. And then finally, we have some bonus slides for just you, the Caregiver Collective. I have sent to Jennifer copies of these documents. This is a free document that you can get online, but a lot of people don't know about it. If you are dealing with a loved one that has dementia and it's going to be probably, you know, progressive, this has I think a 3-part series of what happens when I have mild dementia, what happens when I have greater dementia, and what happens when I have severe dementia. It's really a wonderful document. I sent the link to Jennifer and she's going to put it up for you guys if you want to download it. It's a wonderful piece of paper. Share it with people. It's really a great thing.
Everybody who registered for the webinar, you will receive this in your emails within the next day or so. And anybody who's watching this after we're live, I will have it posted somewhere and I will let you know where that is.
Fantastic. This is my secret forms for the advocate caregiver. These 2 forms have made my life so easy, it's unbelievable. If you fill them out, whether you're a power of attorney or not, and you can have your loved one sign it, assuming they have mental capacity, but if they don't, you just attach your power of attorney. Every time you pick up the phone to call Medicare or the Veterans Administration, they will talk to you without any problem. And if you've tried to talk to them without these forms, you know how horrible that can be, how difficult it is to get them to talk to you without your loved one sitting next to you. And a lot of people, we don't have our loved one sitting next to us when we're trying to get business done. So again, Jennifer has this, and it's in my book, and it's just very hard to find, but once you find it, it's like a dream come true. So please take advantage of that. Also, caregiver contract. You can get paid for your work. from your loved one. The only ones that they question are spouses. But if you are working, and when I say working, I really don't mean this. I mean really working, because I know we're all working. If you're working for your mom, your dad, your aunt, your brother-in-law, your cousin, your good friend, you can have them sign a caregiver contract and you can be compensated, and that will never come back to haunt you in the 5-year rule. But you have a legally, legitimately signed contract. It's the best thing you can do. And that's a beautiful, easy one. And again, Jennifer has that. She's going to be sending that to you. So that's just for you to have. God, the hour goes so fast, I can't even believe it. I just want you to know, yes, the Wicked Witch of the Door came, the Wicked Witch of the West came to your door and started you as a caregiver. But you found some great friends, especially here in the Caregiver Collective, to help you get through this. And we all lift each other up. And you've always had the power, and you will get to the Emerald City. I promise you. It all turns out well. You are doing wonderful, wonderful work. And I am proud to call myself a caregiver with each and every one of you, because I know how hard this is. And I admire your sacrifice and your hard work. So I thank you for your listening. That's my book on the left that has lots of tips. That's my contact information on the right, but I think it's also on the next slide, which is, yep, it's there as well. Thank you for your time. If there's any questions, please throw them at us.
Ellen said, thank you, extremely helpful information. Thanks for joining us, Ellen. If anybody has questions, just put them in the chat box and we'll read them to the group. And I actually want to start off with a question. We're just going to take the next 5 minutes or so because I want to be mindful of everybody's time. But a lot of times people in Caregiver Collective know that they need to have the conversation of these documents like POA, advanced directives. I myself did not want to have it, even though I knew it was necessary. My dad was even worse. We were both in just total another time. And my mom is the one that really pushed the conversation through. And she navigated to have it individually with each of us. But what are some tips that you may have for a caregiver, especially someone who, you know, in this group we're a bit younger, and maybe if we're dealing with parents or grandparents,
right,
maybe they don't necessarily respect our authority
right,
as an adult. Right. What are some tips to have this conversation?
And honestly, that's the key, is authority. I don't know about you, but it's been this way all my life. Even with my kids coming home from school, if somebody else's mom said something, it had some kind of weight, as long as, you know, it wasn't me. But I'd say 2 things I can say. Number one, if you can just say, look, I think we should go to a lawyer and see what they have to say. Whatever they say, that's what we'll do. You know, sometimes putting it in the hands of a professional and getting them to go with you to talk to a lawyer and making it sound like if the lawyer says we don't need to do it, we're not going to do it. It's just that I read this stuff and I'm a little bit scared. The other thing is Dad, this really isn't for you. It's for me. I can't help you and I need help doing this job. And so if you would even just consider about how you could help me do this to help you, maybe we could get this done. And, you know, so it's not about you giving me anything. It's about me being able to help you. So number one, but always I would say, let's just go talk to a lawyer. I read about this. If the lawyer says we don't need to do anything, because that's like wonderful, because they think they're going to go in there and say, the lawyer says we don't need to do anything. We probably don't. And honestly, even a doctor, you know, it's the same conversation with a physician. I can't tell you how many times I would take my mother-in-law to the doctor and just say to the doctor, you need to tell her, you know, she needs to take this medication, or we need to walk every day, or whatever. It has to come from you. It can't come from me. That's where the authority has to lie. So you might even have a relative who they trust more than you as their child. A brother-in-law, a sister-in-law, somebody who's a doctor, or, you know, a lawyer, but even an engineer, somebody that they think is the smart one, right? I encourage you to bring someone else in. Sometimes that's super helpful.
That's great advice, particularly somebody who's a professional who maybe doesn't have the emotional stake that somebody you're related to might.
Exactly. Yeah, perfect. Yeah, Jennifer, that's a perfect question. Yeah, exactly.
Rachel said, thank you as well. And does anybody have any questions that they want to throw in while they have Cathy's wealth of knowledge? Chris also said, thanks for putting this together. Great info. So I'm glad people are benefiting from this, honestly. The more armed we feel the little bit of stress is taken out of our jobs, the more we're educated.
Exactly.
Jessica wanted to know any advice for long distance caregivers.
That's a really good question. A couple things. For number one, take advantage of those online resources. They have a lot of information that can be used for online care or for long distance caregivers. Number two, I would say, even though you're the power of attorney, I would say, if possible, if there's anyone you can entrust to be your, I want to say Sherpa, for want of a better word, who is at the other end, somebody who lives near your parent, a friend of theirs or another relative or someone that, you know, they're in contact with all the time, that you can just discuss what's going on with your parent or your loved one, that would be fantastic. This is assuming, of course, they're not in a facility, because if they're in a facility, obviously there's going to be somebody there that you can talk to all the time, and you need to make sure that you are in touch with them. But, you know, hopefully your person is not living in a vacuum and they have somebody else that you can make a relationship with, and they can be your eyes and ears.
We're going to take one last question because we're at 3 o'clock now. Rachel asked, okay, two questions. Rachel asked, any recommendations about who to talk to regarding financial planning, etc., but beyond the estate lawyer or elder lawyer, who else should we talk to, especially when there's enough money to worry about?
Yeah, that's a really good question. The first question I would have is, does your loved one, does your parent or whatever have a financial advisor? If they don't, then I would suggest that you talk to a financial advisor, but maybe even ask your elder lawyer if they know somebody who deals in this field. You need to look for someone who is in the retirement or financial advising market, but understands elder issues and understands Medicaid planning. Those are keywords right there, Medicaid planning. So look for someone who talks about that. But your lawyer may in fact be connected with somebody, you know, who does that. In Pennsylvania, lawyers are not allowed to sell any kind of financial products. So for us, this is a great relationship because we want to shore each other up to do the best for our clients. That's not true in every state. So of course, you proceed lightly. And I'd say interview at least 3 people. At least 3 people so that you know you're comfortable with them having this conversation about finances.
Rachel says thank you. And
You're
our
welcome.
last question from Malin is, if you can't afford to consult with a lawyer, are there free forms that you can find online that are okay to use for power of attorney and DNR? And do they need to be notarized? How do you make it officially legal without a lawyer? Or is there no way of getting around a lawyer?
I hate to answer this question. Okay. First of all, powers of attorney have to be notarized. So you need a notary. That's an absolute certainty. In my state, I am just so cautious because we have those language issues, which I talked about, gifting and beneficiary designation and things like that, that I really hesitate to tell people. But that being said, we all know LegalZoom is out there. You can certainly go online and, you know, get power of attorney documents. I get scared that they don't technically meet your needs, which is why I prefer a conversation with a lawyer. And so I would say you can do some lawyer homework and you can call 5 law firms and say, how much do you charge for a power of attorney for my elderly mother? I mean, at least know for a fact that you can't afford it, because the truth of the matter is, when we're starting to get into care, you know, this is thousands of dollars probably in caregiving expenses. So the question becomes, really, can you not afford it, or is it less than you think? And I would, at least before you decide to go the LegalZoom way or any other legal, you know, downloading, at least call law firms who are elder lawyers and ask them what the cost is. And if they have any, you know, benefit for someone who is low income or whatever, you'd probably be surprised.
Great. That's great advice. Thank you.
Yeah.
Malin wanted to clarify that personally, she thinks a lawyer is worth every penny, but I have friends who won't can't afford one. So
and Malin, it's not that I don't understand that. I really do. I do understand that. And in a pinch, I'm going to say, get the one. I'd rather you have one online and take it to a notary for $5 and get it notarized than have nothing. You know, nothing. Something is better than nothing. And you are absolutely right. There are people who can't afford it, but and if they just have that document to give them the power to deal with financial institutions and hospitals, et cetera, they should have it. Absolutely, 100%.
Great. Well, thank you so much, Cathy. Thank you, everybody, for joining today and for all of your questions and comments throughout the webinar. And especially thank you to Cathy Sikorski for offering all of this time and information and for free, which, as we're discussing just now, elder law attorneys don't come cheaply. But we're at a time in our lives where we don't really have a lot of savings, and the person we're caring for may not either. So honestly, you spending this hour with us is incredibly helpful. So
you're welcome, Jennifer. And if anybody knows of anywhere I can come speak for any organization that they work for, or, you know, that's where I like to talk, where there's organizations who are willing to, you know, quite frankly, pay me, but I can give this knowledge out to people for free. And I love my millennials. I told Jennifer I have 2 of them, so I'm happy to do this.
And she still loves us.
I do. I love you.
And I think if you notice, Cathy also has written a book, and that's available on Amazon, right, Cathy?
Absolutely. Just Cathy Sikorski. It'll come up. Absolutely. Thank you
Great.
so
And
much.
all of these forms that she mentioned at the end will be emailed out to everybody who registered for the webinar. And everybody else, this webinar will be posted online eventually. It's for Caregiver Collective members first, and those forms will be made available. So thank you again, Cathy.
You're welcome.
Fantastic.
Thanks for having me. Bye-bye.
All right. Take care, everybody. Enjoy the rest of your day.